has already done this by inviting geospatial technologies and human rights projects to conduct a research for the court. This report shed a light on many contradictory submissions of the government of Azerbaijan, in which the respondent tried to deny the fact of its full control and jurisdiction over Gulistan. In this regard, my government also would like to refer to the report produced by Geospatial Technologies and Human Rights Project. I quote, "The image analysis enabled detailed documentation of the significant and increasing military presence in the area, including trenches, revetments, military buildings, military vehicles, and the presence of vehicles, tracks and roads through the area in the period of 2005 to 2009. This period of military build-up was followed over the period of 2009 to 2012 by continued military development in the region, but of a different type, in that revetments and trenches fell into disuse, while military buildings and vehicles' presence continued to increase." End of quote. Moreover, I think it should be decisive for the court that by its letter dated 4 December 2013, the respondent state objected to the disclosure of some images in the report. By doing this, the government of Azerbaijan in fact admitted that the military positions, trenches, military buildings belong to Azerbaijan. I quote, "In this context, we have objections to the disclosure of the satellite images provided in figures 6 to 11, 13 and 14, since they indicate precise information as to the military objects of our armed forces of the Republic of Azerbaijan." End of the quote. Mr. President, I would like to stress that the government of Armenia did not ask the court not to disclose any part of the mentioned report, since no military objects of the armed forces of Armenia or Empire are located in the village of Gulistan. Even based on the above, it is undoubted that the village of Gulistan is under the full, effective and overall control of the Republic of Azerbaijan. Mr. President, I now move to addressing the issue of existence of effective remedy, which this court, by its admissibility decision on 14 December 2011, joined to the merits. The government of Armenia fully supports the submissions made by the applicant concerning the absence of effective remedies in the meaning of Article 13 of the Convention. The government of Armenia also submits that the rule of exhaustion of domestic remedies is inapplicable to the present case in the view of existence of an administrative practice in Azerbaijan to prevent the forcibly expelled Armenians as well as any other person of Armenian origin from visiting or returning to Azerbaijan. Now let me address the last question on violation of Article 14 of the Convention, taken into conjunction with Article 1 of Protocol 1 or Article 8 of the Convention. The government of Armenia insists that the right of the applicant, protected under Article 14 of the Convention, has been violated by the respondent state, as he has been subjected to discrimination on the basis of his ethnic and religious affiliation, in conjunction with Article 1 of Protocol 1 and Article 8. The question of violation of Article 14 rights of the applicant should be considered in the context of Nagorno-Karabakh conflict, de facto situation which resulted in killings of ethnic Armenians and displacement of hundreds of thousands of Armenians from Azerbaijan. It is submitted that only ethnic Armenians were subjected to forced displacement from their homes in Azerbaijan, and such a difference of treatment is discriminatory and has no objective and reasonable justification. We further state that the applicant is denied his right to return by the government of Azerbaijan, and submit that this denial is related to ethnic origin of the applicant. Government of Azerbaijan continues applying its discriminatory policy over ethnic Armenians after the ratification of the European Convention. The government of Azerbaijan, among other barriers, hinders the return of the applicant to his home in Gulistan and enjoying his possessions. The most recent appalling evidence of discriminatory policy over Armenians is the pardon, glorification and release of Azerbaijani citizen ex-murderer Ramil Safarov, who was convicted in Budapest for life sentence for killing of Gurgen Markaryan asleep and attempted murder of another ethnic Armenian officer. In 2012, Azerbaijan government acknowledged and endorsed the crimes of Safarov, which was clearly caused by and founded on ethnic hatred towards Armenians. This act of the Azerbaijan government was widely criticized by the international community. The government of Armenia concludes that the applicant has been subjected to a direct discrimination by the respondent government on the grounds of his national origin. Therefore, his right guaranteed under Article 14 of the Convention in conjunction with the Article 1 of Protocol 1 and Article 8 of the Convention were violated. Thank you.
Thank you very much, Mr. Kostanyan. Question from the judges, Judge Luis Lopez Guerra.
Thank you. Yeah, my question is mostly to the representatives of the Azeri government. It seems to be from the statement that it's relevant in this case, the context, the geographical context, taking into account that Gulistan or the property of the applicants seems to be in or near the euphemistically called line of contact, of maybe should be called front line. Well, apart from all the general disasters deriving from a conflict, such as the existence of refugees or displaced or expelled persons, it seems to me that there are specific damages for property, personal or real property, deriving from this situation in the front line or the line of contact. Specific damages different from general expulsion of persons or displaced persons. Now, my question is there in Azerbaijan some specific normative or regulation concerning this particular and specific damages resulted from direct military action or violent action in the line of contact or the front line? I mean, is there any specific provision in the legal Azeri order in this aspect? Thank you.
Thank you, Judge Paulo Pinto de Albuquerque.
Thank you, Mr. President. My question is addressed to the applicant. The applicant did not address the main argument of the respondent government regarding jurisdiction. The respondent government say that they prohibited access of civilians to this particular area because it is dangerous. And they gave an order which is secret with that purpose of avoiding civilians in that particularly dangerous area. It would be, in their view, unreasonable to request the respondent state to permit access to and circulation of civilians on the line of contact, on the ceasefire line. I would like to hear the position of the applicant on this specific argument, having in account Article 57 of the 1977 Geneva Additional Protocol to the Geneva Conventions, which relate to the protection of victims of international armed conflicts. And there you find that there is a legal obligation, an international obligation of states regarding victims of international armed conflicts, and specifically states have the duty to provide for all reasonable precautions to avoid any losses of civilian lives. My question is, the legitimacy of this order of the respondent government is, yes or no, grounded on international humanitarian law and the law of war? Thank you.
Thank you, Judge Gillian.
Thank you, President. I have two questions to the respondent government. My first question is somehow continues the question which have already Judge Albuquerque has already put. My question is, you stated that it is for the security reasons that applicants didn't allow to come back, to return back. I know very well the area. There are many other villages which are with the same distance from the contact line, which are in the border, on the border, but populated by Azeris. How is it that you can guarantee the safety of one group of people and not the others? This is my first question. And my second question concerns your oral submissions about the Armenian government's refusal for the return of refugees. You have stated that Azerbaijan voted for the return of refugees in the General Assembly of the United Nations. What was the resolution which you have mentioned? Did you mean the resolution against which voted also all member states of the Security Council and the states which are in the Minsk group? If it is so, was it the only point in that resolution? And Mr. President, I have also one factual question concerning the Azerbaijani government statements about the 20% of their territories which are under the control of the Armenian forces. I would like to have more precise figures. What is the territory of Azerbaijan and what is the territory which you mean that under the control of the Armenian forces? I went through different sources and I found that the territory of Azerbaijan for the moment is 86,600 square kilometers. And the territory of Nagorno-Karabakh is 4,388 at the time when it was in the Soviet Union. And now it is 11,458. I would like to know whether 11,458 square meters is 20% of 86,000 square kilometers. This will be my question, and I hope I will get answer to my questions, unlike in the previous hearing when I didn't get any answer to my questions. Thank you.
Thank you. May I ask the respondent government to put the three maps on display, maybe on the floor in front of the court, to enable counsels for the applicant and the delegation of the Armenian government to have a look at them during the break we will have. And we will have a 20-minute break and we will resume at 11 o'clock. L'audience est suspendue.